And Sells. So, Mr. Rojas, you've been appointed to represent Mr. Sells. Is there any reason to believe that the person standing before me is not Mr. Sells?
No, Your Honor.
And so I'll take judicial notice of that, as well as the court's file, including a report. Mr. Sells was evaluated for competency to stand trial by Dr. Hamza. I have received that report dated November 14th of 2025. The finding is that Mr. Sells is not competent to stand trial at this time. Is there any other evidence with regard to competency?
No, Your Honor.
Not from the state here.
Then at this time, based on that evaluation, I am going to find that Mr. Sells is not competent to stand trial. I'm going to order inpatient treatment at the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility, and then we'll await a report from that facility. He can go back with the bailiff.
No, go on. I'm not trying to get.
We're going to get you, yeah, we're going to get you some help, and then you can come back and take care of your case, okay? Go back with the bailiff, okay?
Bailiff for what?
Right there, go to the back, okay? Go to the back. Mr. Garcia, you tested positive for marijuana, amphetamines, methamphetamines, and ecstasy. Did you drive here? Oh, you're surprised about the ecstasy?
Yeah, I'm surprised about that.
Wow.
I did smoking, I did relapse a few days ago.
Yeah. All right, so I'm going to find, obviously, that that is a violation of your bond conditions. I also told you last week specifically that you had to be here on time. No, you were not here. And so I'm going to raise your bond in your case to $100,000. If you make that bond, a condition of it is that you have a drug patch on at all times, that you also have a GPS monitoring device and remain in Jefferson County, since you can't seem to get here on time. We'll figure that out. Talk to your attorney. You can go back with the bailiff.
We now call cause number 23-41394, the state of Texas versus Kelby Green. That's you. Present with Mr. Adams, your attorney, and the state's attorney. There is a second amended motion to revoke unadjudicated probation that's pending. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes.
In summary, sir, and raise your right hand. Do you solemnly swear or affirm any statements you make will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
In summary, this motion states that on July 31st, 2023, in this court, you were placed on 10 years deferred or unadjudicated probation for the first-degree felony of aggravated assault. Was all of that true, sir?
Yes, sir.
Which one is he pleading to? Yeah. We've got failing to report.
Yes, sir.
Number one states violation. You failed to report the Jefferson County Probation Office on or about December 13th, 2023, January 10th, 2024, January 29th, 2024. Did he become an absconder? No, he just missed those dates?
He shut up.
Okay. What happened on those? Why didn't you show up on those?
Remember I told you I got shot?
I'm sorry?
Somebody explained to you last time I got shot.
Yeah. I've got 5,000 defendants here. You're familiar? I just don't remember that conversation. Tell me again. What happened?
I had got shot in July.
And then you went to the hospital?
Yes, sir.
Okay. So you weren't able to report because you were in the hospital?
I couldn't even walk.
Okay. Well, we're not going to get him on that. I mean, if he couldn't make it
But he had,
physically, then
Right.
we're going to have to do something else. I'm not going to revoke him for that.
no, but he has a whole lot, like,
All right. Let's go to
14
something else.
violation.
Well, give me another one. What's this number 12?
I think,
Committed the offense of illegal possession of a controlled substance in September 25.
yeah, that's not foul, yeah, but what I was looking at, Judge, is
Whose court is it in?
I think that would be in drug court. But he had tested positive for marijuana on 2 separate occasions. In June 24th, tested positive for marijuana. And then he also tested positive on September 4th.
Yeah.
And he also didn't do that.
Okay, hold on. Number 8. This states he provided a urine sample on June 24th, 2025, which showed the presence of tetrahydrocannabinol or marijuana in the system in violation of his probation order. Is that true? Are you pleading true to that voluntarily because it is true as it is alleged?
Yes, sir.
Do you understand that a voluntary and knowingly made plea of Treaty 1 or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked. You can now be found guilty and sentenced up to the full range of punishment. This is a first-degree felony, no less than 5 no more than 99 years confinement in prison or life imprisonment. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. All right, let's see where it goes. An agreement's been reached where your probation would be revoked. You would be found guilty of this aggravated assault and sentenced to 5 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
Show you what's marked. States Exhibit 1 here. You need to sign that document voluntarily, understand it, discuss it with your attorney,
Yes, sir.
or the contents are true and correct.
Yes, sir.
States Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's submitted. Among other things, this states you were giving us all rights of appeal if I follow this agreement, which I intend to do.
Yes, sir.
Anything else to add? Then I will find that you have pleaded true voluntarily to allegation 8 of the first amended portion of this second amended motion to revoke unadjudicated probation in this cause number 23-41394 case. You were mentally competent to do so. This was voluntarily and knowingly made. It is enough to grant the motion to revoke probation by preponderance of the evidence or greater. I so find that to be done. Your deferred or unadjudicated probation is hereby revoked for that violation of probation. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt.
Yes.
In this case, I am following this agreement. You were hereby sentenced to confinement for this first degree felony of aggravated assault, confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. There will be an affirmative finding that a deadly weapon was used or exhibited in the commission of this offense, namely a knife. Do you understand what has happened today?
Yes, sir.
Anything else to add on this?
Nothing from the state.
If not, that is all. Thanks.
Take it easy. Good luck. Yeah, they don't get their own first.